Good evening. Happy Tuesday. Two videos in one day. What? Is it your lucky day? I think it is. So I listened to the no bond hearing that was set for today. It was set for 2:30. They didn't get to it until about 4:30, if I remember correctly. Maybe a little early, maybe about 4 o'clock. Yeah, about 4 o'clock. So it was streamed on YouTube. You can watch it directly by clicking. You go to the there's a Supreme Court's website that you click for multimedia where you can watch Supreme Court stuff. Then you can select Superior Courts, and then you select Pima County, and then you search by the name. So first name or last name. I chose Myers. It pulled him up. There was a link. It was room 357, I think. And so I clicked on that, and it took me to a unlisted YouTube video where you could watch it. So if that helps anybody, there you go. I hope to watch the second hearing tomorrow, because that's going to be the fun one. In this hearing, the state presented its evidence as to why Lane should not get bond. That's all this hearing is about, is whether or not Lane should get bond. Not whether he's guilty or innocent or what. It's whether or not he should get bond. Was he in fact violating bond conditions? Was he continuing to harass in violation of an injunction, et cetera, et cetera, et cetera? Those are all important questions, but the only question that the court needs to resolve is whether or not Lane should get bond. And so the courts, generally speaking, and I don't practice law in Arizona, so maybe Arizona is a little bit different, but generally speaking, the courts look at two things. Number one, how likely are you to run? Do you own property in the area? Do you have a job in the area? Do you have family in the area? Have you run in the past? Have you not run in the past? All these things are indicative of whether or not you're a runner. Now, I don't think anybody's claiming that Lane's a runner, so they're not focusing on that. What the state's focusing on is whether or not he's a danger to the community. There is the other thing that you look at is whether or not someone's a danger to the community, and their whole case is that Lane is going to continue to harass the alleged victim if they let him out. And he created sufficiently strong evidence that he will in fact continue to harass if they let him out. So I can see why the state doesn't want him to be out on no bond. Now, there is a constitutional requirement that for bond, and the state has the burden of showing that either you're a runner or you're a danger to the community, or else you were entitled to bond constitutionally. But like every constitutional right, of course, it is not absolute. So, if the state meets its burden, you don't get out. Now, the state presented a very competent case today. I didn't see any real problems with it. It was, run of the mill. It wasn't spectacular. It wasn't bad. It was a competent case. Lane's attorney was doing fairly well, objecting appropriately, although his objections weren't quite as succinct. He's doing what we call speaking objections. Now, normally what you're supposed to do is you're supposed to say like objection relevance, objection hearsay, objection this, objection that. You're not supposed to say objection, well, I really don't think blah, 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 blah. That's what's called a speaking objection. And some judges will frown on speaking objections. Some judges don't seem to care. In this particular case, the judge didn't seem to care. But generally speaking, to me, it's indicative of an attorney who really doesn't have a good grasp on what objections are and or should be. Your mileage may vary. I wasn't terribly impressed with the public defender. Another thing the public defender did that I don't really agree with, because the public defender has a job, and that job is to adequately represent his client, not necessarily to do what his client wants. So the client gets to pick the end goal of the representation, but the lawyer has a duty to figure out how to get there. He figures out the procedure. He figures out what to present, what not to present, what objections to make, what objections not to make, what legal arguments to make, and what legal arguments not to make. That is the purview of the lawyer. The client says, I want to get out if you're on bond. The lawyer gets to pick the road to get there. But this particular lawyer was quite apparently listening to Lane and asking the questions Lane wanted asked, which weren't really relevant to the hearing, to be perfectly blunt. They weren't relevant at all. And then there was something about a state actor. He wanted to know if the victim was a state actor, and he's asking this question of the detective, and whether or not somebody's a state actor is a legal determination. And Lane Myers couldn't help himself; he had to spurg out at that point, and he started citing 42 USC 1982, which of course is a federal statute, has absolutely fuck all to do with a state case in the first place, but it has even less to do with whether or not he's a runner or he's a danger to the community. And then he cited, what was it, ARS 12-751, which is, I believe, the anti-SLAPP suit, which for the purpose of that section defines a state actor as like, and I might be saying state actor wrong, but it defines it as like the state or one of its subsidiaries, the county or one of its subsidiaries, a city or one of its subsidiaries, or an employee thereof if they're acting in their official capacity. And that's important, and I don't think that Lane gets that, is that they have to be acting in their official capacity. So just because someone is, say, for example, an employee of the state, if they're on their boat on Lake Havasu having a drink and you decide to be a jackass and get up in their face and they hit you, that doesn't mean it was a state actor acting. So there you go. They have to be acting in their official capacities. Now, I don't think ever in all of this has she been addressing him or directing anything towards him in her official capacity as director of something or the other at the Arizona Law School. So again, someone did send me a copy of the SLAPP motion. I haven't read it yet. It's 40 pages. Believe it or not, I do have things to do from time to time that actually pay me money instead of cost me money. So so I hope to get to it, but if I don't, well, then I don't. And the mosquitoes are coming out, so I got to make this quick. So anyway, at the end of this, Lane's attorney didn't know if Lane wanted to, what legal arguments Lane wanted to make, because Lane wanted to represent himself, but he couldn't do it at that hearing. And also didn't know if Lane wanted to testify on Lane's behalf, which I'm sure will be detrimental to Lane's case, because Lane is a spurg, and I have never once seen him able to control himself for any reasonable length of time. So it's a bad idea. I don't recommend it. One other thing that I don't recommend is they played some voicemails and they read some emails that were questionably legal at best. And I just want to caution everybody who's doing this stuff on Lane's behalf that you might be making yourself potentially a defendant in your own little criminal action. So I suggest to you that you be circumspect. If you do want to call, I don't recommend you call, first of all. I don't recommend you call. I don't recommend you write. It won't do you any good. It won't do Lane any good. In fact, all the calls and emails have done so far is get Lane further in trouble and might get him on a no bond. So, that's kind of sucky. So just be aware of this. But also, it won't help him in the future if you continue to call, and it might expose you to criminal liability. And just remember, we have seen people get put into federal fuck me in the ass prison for playing these fuck around and find out games. And so I'm just not recommending it. I don't want to see anybody, including but not limited to Lane Myers, behind bars. So the hearing was continued to tomorrow at 2:30. I don't know if it's going to be the same link. It may or may not be. And that 2:30 is Arizona time, which is currently California time, but hey, it's subject to change. So if you want to watch, great. I'm going to be watching. I will be probably commentating on my Discord main chat as if anything interesting happens, or if not, well, then I'll probably just watch it, eating my popcorn as I normally do. But good luck to you, Lane Myers. I hope you don't F yourself in the a-hole. Again, I don't like to see anybody behind bars, including idiots and assholes. Thanks for watching. Have a great day.